Welcome to Ground Rules, Employment Law Over Your Coffee Break. My name's Pam Howland, and I'm here with Doug Plass and Jennifer Walrath, other attorneys at Idaho Employment Lawyers. And we're here today talking about why we can't just make your lawsuit go away. So you might be wondering where we came up with this topic and why we wanted to devote a little bit of time to this issue. And the answer is that this is one of the most frequently asked questions that we get, and it causes us a whole lot of stress and anxiety when it comes to practicing law and litigating cases. So litigation's a big part of our practice. We're all litigators and we all argue cases in Idaho state and federal courts. And what we know from our litigation practice is that once a lawsuit is filed, it's difficult to make it go away. And even when you feel like there's a bogus claim, a claim with no merit, it still is very hard to make that lawsuit go away. And we want to spend a little time telling you why and telling you kind of the realities of being pulled into litigation through the court system. So recently, we went through our files and did a little bit of math, which for me was like a large undertaking, but we did it. And what we discovered is that on average, in our law firm, with the lawsuits that we handle, it takes nearly 3 years on average to resolve a case once the lawsuit is filed. Some cases it takes longer. Some cases, maybe they resolve quicker than that. I've had cases in my legal practice that have taken nearly a decade to resolve. That's fortunately not the norm, but the reality is once you get pulled into the court system, you can count on it being a multi-year undertaking to make a lawsuit go away. During that time, you can count on attorney's fees incurred in the defense, and on average, even when a case does settle, which most of them eventually will, we know that few cases actually go to trial. But on average, settlement in the employment law arena typically runs around $130,000. And again, that's not counting attorney's fees that you as an employer might incur in the defense. So the process is long, it's expensive, it's time consuming, and I can tell you firsthand by working with clients who are litigating cases right now, it's frustrating for employers who are pulled into the court system. So why can't we make your case go away quickly once it's filed? Let's dig into that a little bit more. So, Doug, tell us a little bit about the path that litigation of all types typically take once the lawsuit's filed. Sorry.
Yeah, thanks, Pam. Yeah, the question of why we can't make it go away is something I beat my head against daily. And part of the reason is that all lawsuits have to go through a certain process, right? So first we have the complaint filed, and then we have an opportunity to make a lawsuit go away at the motion to dismiss stage. But really that only ever gets granted if there really isn't much of a claim to begin with, or if the lawyers have done a pretty horrible job of representing it, or if something like the statute of limitations is blown or something like that. Usually some pretty simple things. And then if we get past that, you're in discovery, right? So this is where the parties exchange information. This can take a year or more to do, and it takes time. There'll be written discovery, there'll be depositions, there'll be all these things that allow everyone to understand what all the facts are. And then you have another opportunity to make it go away at the motion for summary judgment stage, where parties can say that as a matter of law, we win or they lose. And then if you get through all that, then you start getting ready for trial. But, add it up and consider a little bit of time. It's pretty easy to see why things take 3 years or at least 2 years. Yeah.
Yeah. So, Jennifer, tell us a little bit in your experience. What do you see as some of the roadblocks that we encounter in getting a case quickly resolved?
Yeah, I mean, a couple thoughts, kind of piggybacking on what Doug was saying. Unless there's a very clear legal reason why one party should win over the other party, there's a tendency to let the parties have their day in court, let a jury of your peers decide the case, right? Judges don't love making decisions. Well, they aren't supposed to be making decisions if you're weighing facts, credibility of witnesses, things like that, right? And oftentimes, if you get as far as what Doug was saying to summary judgment, those are some of the issues that could still be lingering, right? There are things where the parties don't agree necessarily on what happened, or the significance of something that everyone agrees happened, right? And sometimes judges can whittle down the issues in the case and kind of narrow things. But I would say it's pretty rare that summary judgment wholly disposes of a case and can get rid of it at that stage. And again, you've already gone through a lot of time, effort, money, diverting resources from your business, your people are getting deposed, you found documents. So even getting to that point takes some time and effort. And I would say the other thing I've noticed is parties are not always strictly rational beings settling a case, right? So sometimes there are other factors, other considerations, other things the parties want. That includes our clients, that includes the other side, right? And sometimes it just is not really feasible. Even if you look at a case and say, look, you might only get this amount of money if you're the plaintiff, but you might have to spend some money to get that at the end of the day. They'll say, but I am right and I want to win. And sometimes employers are in a similar boat, right? I didn't do anything wrong and I want to be vindicated that I didn't do anything wrong. So sometimes it really is the parties having a goal or a feeling about a case that isn't necessarily a matter of fact or a matter of law that just makes it hard. Because I will say a lot of the same clients that come to us and say, I want you to make this lawsuit go away, will also say, but I am not willing to give that person a shiny penny, right? I'm not going to give them anything because they're wrong. Fair feeling, for a lot of our clients, but it does make it very difficult for a case to actually get resolved before going down the road a little bit and spending some time and money on litigating it.
That makes me think about something, a couple of years ago when I was starting out, I was on a phone call with opposing counsel and we were talking about, what do you think? Do you think that we're going to be able to resolve this? And what the opposing counsel said was like, I think everybody needs to hurt a little bit first. And I think that's true, right? That's how people's minds get changed. That's how people get motivated to settle things is they realize, gosh, this is really uncomfortable. And that's unfortunate, right? Nobody likes that. But, the fact that litigation is miserable is what actually ends up settling cases.
And I will add too, the same thing I think happens for claimants. Sometimes they have in their head that their claim is worth millions of dollars. And that's not practical. It's not reasonable. It's not what ultimately happens. But it takes a while to change the mindset to get them down to what, if we're a defense counsel, would see as a more reasonable place to be to settle a case. And I think the other thing I was going to mention, just in terms of the time it takes to get down the line a little bit when you're going through the process that Doug described, that always takes some time just because of the deadlines and the time periods built into the rules that we follow. But on top of that, I would say increasingly here in Idaho, maybe other places as well, but certainly you've noticed it here in Idaho, the courts are very, very busy. And, here in Idaho, we are what's called a notice of motion or a hearing state. So we hear our motions, and basically the schedule for being able to get things decided is driven to a large degree by when the court has time available to take up your motion and hear the arguments and decide the matter. And sometimes we've had courts say, I really don't have any time until, next month or 6 weeks out, because their calendars are just very full and very busy. And that just adds to how tough it is to get quick and easy resolutions. it's not the court's fault necessarily. It's just kind of practical reality. And I think we would say it seems like it's been more challenging since COVID.
Yeah, we had a case a couple of years ago where there were cross motions for summary judgment. So both sides were moving for summary judgment, and the court heard one side and then ran out of time, and we had to reschedule the hearing, and it was almost 2 months later before we finished a hearing. So
and that was the first available date. So that wasn't the judge just saying, I'm going to wait a little while. That was just the first time she was able to pick it back up again. So.
Yeah. Yeah, I have so many thoughts and so many comments on all of that. But kind of along those lines, I mean, we have different courts, right? Like, so we have our Ada County courts, and then Canyon County has separate courts. And I know I've had cases in Canyon County, for example, with judges who only hear civil issues maybe like 1 day a month. And then if that judge is gone, you might go to notice a motion and have the clerk tell you, well, you're probably 2 months out. So I think frequently people involved in litigation are shocked at their inability to get in front of the court. And even when the lawsuit first starts, Doug touched on this a little bit, every judge is going to put a scheduling order into place, and the standard scheduling order has trial taking place at least a year out. And I would say in at least probably 80% of our cases, that date is going to get pushed out because we can't get everything done that we need to get done to take something all the way to a trial. So it's not unusual for a trial date to get kicked out multiple times.
And that's got to be so frustrating for the parties, right? When you see that trial date on the scheduling order, you think, aha, this is when it's finally going to be over. And then you have your attorney say, well, no, it's not. And the immediate reaction is, well, what went wrong? And really, it's nothing. It's just that things take a long time.
Yeah. Yep. And we have a case pending where the judge has vacated the trial date multiple times now. So at least twice. And so sometimes it's not even the parties looking to move the case out. It might be a court that has to put other cases in front of it because of rule requirements or statutory requirements. So there are so many things that can completely hijack your ability to get your case moved forward. So Jennifer and Doug were both talking a little bit about how there are very limited situations where a court will dismiss a lawsuit early on, because we hear that from clients a lot too. Like, hey, look, I've been sued, but you should be able to easily wrap this up because the allegations are completely false. There's no merit to them. So, hopefully you can just get in front of the court and the court will kick the lawsuit out. And as Jen and Doug were saying, that rarely happens because our judicial system is set up so that parties get their day in court in front of a jury. So a lot of judges are not inclined to dismiss cases early on because the facts and the evidence haven't been established yet. So it's really hard to get cases dismissed early. I was telling Doug and Jen this story that I recently, Jen doesn't like this story, but I still think it's a good one. So we had a situation where we were in front of a retired judge recently, and he was explaining his interpretation of how judges can somewhat be divided into two different camps. So he was describing it as there are some judges that he would call innies and some judges he would call outies. And the innie judges are going to keep the case in play no matter what, so that the parties get their day in trial in front of a jury, whereas outie judges might be more inclined to make a substantive ruling that could enable the parties to avoid a trial. So in his mind, judges kind of fall into one of those two camps. So even if you have a case that possibly maybe there are good legal arguments if you get in front of a judge who's not inclined to grant motions that would take the case out of play before it ends in front of a trial through no fault of your own. You might still end up on a path towards trial, which I would say is rarely a good outcome for the client. Why? Because it's so expensive. Like taking a case to trial, so expensive, and so uncertain. What we know here in Idaho, based on some recent data that was compiled, is that over the last 5 years, the average jury verdict for employment law cases is right around $1 million, which that is a shocking figure. It's so high. Now, granted, there's not a lot of cases going to trial, so the total number of cases looked at, there's not a lot there. But you have a lot at risk. Like you get a juror that doesn't like your case, that doesn't like employers, that finds a plaintiff sympathetic or persuasive, even if you feel like you have a strong defense or a good damage claim, you might end up not prevailing at trial. There's a lot of wild cards there. So those are all things that can impact our ability to get your case resolved early.
Well, I was just going to throw onto there kind of one of the common themes throughout a lot of what we've been talking about is that once you get into the court system, there are just a number of things that are outside of your control. How the other party behaves, what decisions they make, arguments they make, how the judges decide things, how they look at cases. Even what the rules say to do. There just are a lot of different things that court calendars, right? We can do what we can to position your case in the best place possible, to try and get in front of the judges and courts timely. But at the end of the day, there is just a lot that, we as your attorneys and you as a party just don't have any say in.
Yeah, we were talking about, this idea of that courts might kick the trial date themselves. And part of the reason that is because they might be double or triple or quadruple set on that. You see a trial date, you think, I have a trial date. And you realize that 4 other people have the same trial date. So, that's part of it as well.
And that's caused huge frustration for clients that we've had because from our perspective, it feels like there's really no mechanism to get in front of a judge just how expensive it is for a trial to be vacated at the last minute. And yet we have seen multiple situations where our clients are gearing up for trial. They're doing their witness lists, their exhibits, their motions in limine, their jury instructions. They've just spent a huge amount of money getting everything teed up for the final grand finale, this trial, only to have the judge vacate the lawsuit, which results in a huge amount of lost money and attorney's fees. Yeah, talking a little bit about what Jennifer was saying, all these things beyond your control, that's another thing that it's difficult for employers to understand unless they've been through litigation is just how unpredictable the cost and the time is going to be. We will occasionally have clients say, hey, I'm going to need you to put a budget together at the beginning of the case. And for us, that is a near impossible task to fill. Why? Because we have no idea how the case is going to go. And again, it's not like we haven't been doing this a while. I'm now rolling into my 25th year of practice, and every case is different. We don't know when the case starts how many depositions the other side's going to take, how hard it's going to be for us to get evidence that we're entitled to, how many subpoenas are going to get issued, how many, motions to compel are going to be made. I mean, all those things have a way of, totally escalating the cost and the time, but we just don't know until the case starts how it's all going to go down.
And we might not even know then, right? So, parties can amend their complaints, right? So, sometimes you see, oh, that's just a wage claim, looks like a really simple thing. And then you get going along, and a few months later, there's been an amendment to add 4, 5, 6 other claims onto it. And you're dealing with a completely different animal.
Or parties. It might be like a seemingly simple case, and then suddenly several other parties get brought in, other claims get brought in, and now you're looking at a fairly complex case where the costs have completely gone up. Another issue that we see here and that we've talked about on prior podcasts is what we have seen in practice is that there are some attorneys who seem to intentionally litigate their cases in a way aimed at what Doug called making it hurt for the other side, right? It may be parties, and again, I wouldn't take this lightly, and I wouldn't say it if I hadn't seen it repeatedly over the last 5 years. But we've had a number of cases where we've seen parties destroy evidence, lie under oath, refuse to produce documents, or claim that documents don't exist. And if you can't get the evidence you need to put your case on, that makes it impossible to wrap the case up. It makes it impossible to get the right arguments in front of the court, to really take advantage of the procedures given to you through the scheduling order. If you can't get evidence, and if the rules of procedure and evidence and professional conduct aren't being followed, all of that complicates it and makes it really hard to get your case wrapped up. So those two make for delay and difficulty in resolving cases.
And some people are just, some attorneys are just pretty hard-headed, right? I think they maybe have had some benefit by playing hardball, and that's what they're going to do. And they make pretty outrageous demands and won't be, reasonable. And I think that, I guess you can see why parties are emotionally involved, but I think as attorneys, we have to be detached to a certain degree. And whenever you see that, that's really hard. There's been a number of cases that we've had recently where we're like, gosh, this thing should settle. Why isn't it settling? And we just don't have any control over what the other side's going to do.
Yeah. And I'll also say in fairness too, I agree with Doug and what Pam is saying, but also we tend to represent employers who see more than one claim at any given time and maybe have a different perspective on what is reasonable, right? This individual person believes their entire life has been, entire work life has been destroyed by the employer and it's worth a whole bunch. And the employer might be sitting here with a very different perspective, right? Because of their past experience and past claims. And so kind of circling back to, I just think a realization that sometimes the parties are coming at it from very different viewpoints, maybe fairly so, maybe unfairly so, but nevertheless, different viewpoints. And that is among the reasons why some of these things just don't get resolved early on.
Yep. So all of that is why we try to spend a fair amount of time really emphasizing the importance of training and how key it is for leaders and business owners to try to avoid litigation and the court system altogether. That's why we started this podcast. And that's why we wrote our book, Law for Leaders, which gives basic, step-by-step instruction and kind of a desk book guide on how to stay out of court and how to maneuver through common employment law issues that arise over and over. What I can tell you with complete certainty is if you make a mistake that could have been easily avoided that ends up in a lawsuit, you're going to have some regret on that. And there are a million ways you can find resources to get the training you need to stay out of court altogether. Some of it is through us. We have our book, we have our podcast, we do quarterly trainings, and we have our Law for Leaders virtual and in-person training. We see a lot of savvy employers around town who have quarterly training and who do everything they can to make sure their supervisors get the info they need so that they can flag key employment law issues before they turn into a lawsuit. That being said, there's also a lot of other resources out there, right? We talk a lot about the EEOC updates that come through on the EEOC emails. We talk a lot about SHRM. We have here in Idaho our SHRM conference coming up in September. So be on the lookout for that. And SHRM also, if you belong to it, kicks out a ton of content that is very good and basically like real-time updates on things going on in the employment law arena. And I think we can all agree there's a whole lot of changes going on in 2025 and probably will be a lot more before the year's over. So that's it for now. Join us next time on Ground Rules, where we'll take on some other key employment law issues.
Okay. Ground Rules hosts and guests are not providing legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction.